Welcome, everyone. We were waiting for the right time to start. I'm Roger Shumaker, a member of the firm here in Cleveland, chair of the Estate Planning and Probate Practice Group. With me today is Mike Witzke, a member in our Detroit office, and Kate Wensink, our colleague here in Cleveland. We'll be happy to answer questions, if we can fit them in, during the program. You each have a question card. If you hold it up, somebody on our staff will pick that up from you. On the internet, people can email us at the address shown on the screen, and we'll get the email delivered to us. If you submitted questions in advance, we'll try to answer most of them. Some of them are a little off topic, and we'll get back to you by email on that. They were more technically and tax oriented than what we expect to discuss today. You're welcome to join the conversation today on our Twitter feed by using hashtag MHBusinessHour. Let me set the stage for our discussion with a few introductory comments. Estate planning is an art in a sense. It's a process that intends to accomplish a client's objectives for the disposition of their estate in both cost-effective and tax-efficient ways. Probate and trust administration is more of a science, applying property and tax law to the assets owned by a decedent, consistent with the provisions of their estate planning documents, a will, one or more trusts, beneficiary designations, and so on. But underlying all of this are multiple family issues, or more broadly, beneficiary issues that may never be discussed. In some cases, it's too painful. There are also aspirations that the client will have for his beneficiaries or her beneficiaries. While these may be addressed indirectly through special document provisions, they will more likely be expressed in other ways: family conversations, expressions of intentions, and in some cases by formal legacy plans. Underlying all this is a concern that the wealth transfer process may have accomplished the objectives, but in the hands of one or more beneficiaries, something will go wrong and the intended benefit will be wasted. There are no surefire ways to prevent a bad result. However, we believe that most people can do something to convey meaning and purpose to their beneficiaries. We'll explore some of our thinking today based on our collective experiences. We don't have all the answers, but hope that our discussion will inspire you to bring up these issues with your own family or with those you advise. We won't address a few of the questions, as I mentioned, but we'll do our best. It's not that they are unimportant, it's just that they would take a little too much time given our topic. With that said, we'll start with this question that we received in advance that will highlight the importance of this process. What percentage of wealth transfers are not successful if success means maintaining assets, control, and family harmony? And an add-on, how do you assess if a family has risk factors present that may indicate above average chance of an unsuccessful transfer? Mike, I'll let you address the first question. I think the second one is broad enough. We're going to cover it throughout today. So, okay. Mike?
Well, in a study that was done over a 20-year period of watching wealth as it passed down through families, Forbes reported that about 70% of wealth transfers end up being unsuccessful. So that means that only 30% of folks are successful in having their wealth transferred in a way that they would have wanted it to, without it being dissipated very quickly after their death. The study identified really three factors that separated that 30% that had success with the 70% that really failed. The first was that the family had a clear mission, and they understood what the objective was, what was success in this wealth transfer. Then number two, they had a strategy, and they outlined that strategy, and really what it comes down to is they had a plan in place to make sure that that mission would be fulfilled. And then the third piece that made these families successful was open communication. There was communication that started well before they passed with the family as to what this mission was and how it was going to be implemented once they were gone. And so really that's kind of talking, what we really want to talk about today is helping families kind of come up with that mission as to what they want to, and our job is to help them get that strategy in place. And then also to foster the communication among family members so that we're going to get them into that 30% as opposed to the 70% who fail to plan.
Quick follow-up on that. I think that this type of planning has been most actively pursued and implemented in closely held businesses, the family-held business. What do statistics show in that area?
Well, I mean, going from the first to the second generation, they're about the same. About 30% of family-owned businesses, succeed into the second generation. You go beyond that, though, and the numbers drop off significantly, down to about, I think, 12% down to the third generation, and only about 3% into the fourth generation. So when we talk about that second piece of, where do we have issues where there's going to be maybe a greater chance of failure in this is when we have that family business. And part of the mission of the family is to have that business passed down through the generations. It shows you how important that planning of the strategy really is. Good.
And it seems to me that this has become a more popular topic in light of the much larger estate tax exemptions, that people aren't as focused, and they now have time to think about something other than, will I reduce the taxes to the lowest possible amount? They suddenly realize there's a little more to deal with, and that making that an effective transfer to their beneficiaries becomes much more important. So Kate, what's been your experience in how this framework of family mission and values, how does that come up? How do we create those kinds of things?
Well, for some families, it's been that way for generations, and so there's not much for us to do but to kind of guide the family along the way as this generation transitions from what they learned from their prior generation. In other families, because this is a little bit of a newer topic, for those that have not looked at this long-standing inherited wealth, it's a place for advisors to guide. So sometimes we'll see that a financial advisor and the CPA and the attorney will get together with a family. Perhaps if it's a family business, the CFO will be part of it. And that's where that guidance takes effect. And really that starts in a conversation in somebody's office. You'll get a little snippet of in a family meeting, not even a family meeting, in a snippet of an estate planning discussion. So-and-so's leaving for college, or they just came back and you wouldn't believe what happened at the business this week. And that opens the discussion to family values and what do you want for your children. And that's, and then that's where you see some people having family meetings, and not a bad thing.
Right. Yeah, I think one of the core issues for many in our culture is education, and so we often deal with assurance that everybody in the family has that opportunity. I think timing of the family meeting sometimes is a before and after. A lot of times, a strong-willed parent generation will say, well, these are our family values, and they'll present it, or have questions about presenting it. A good friend who's a legacy advisor has an answer. I don't know that it originated with him, but he does this kind of thing all the time. And in answer to the question, should we have a meeting, he said, the question is, will you be there? Because there'll be a family meeting, but if you're dead, I don't know whether you'll get to see it or not. So I think communication is really core, and a lot of families don't do that very well. But this is an issue that deserves the extra attention.
Well, and with respect to communication, it should not be at the first family meeting that a balance sheet for the family is just thrown out on the table if the family has never operated that way before. That may not be the appropriate way to move forward. It may be a very general, broad brush stroke. These are some of the things we've done. We've worked very hard. You'll notice we've worked very hard because you've noticed we've accumulated certain things, or because we've been able to give back to the community. You've been there when we've been volunteering together or donating together, but it doesn't have to be, here's what the bottom line is. That can come out slowly over time, and sometimes not at all, so long as the family knows who are the advisors, who do we go to.
And I think, Kate, it's important that this is not something that happens in just one meeting where you sit down with the clients, but when you're having really some probably difficult conversations with the clients about the family, about the qualities of each of the members of that family, where they fit in the overall puzzle. And I think we're going to talk later today about when you have a family business where some family members are active in that business and other family members are not active in the business, how do we deal with those issues as to how that business is going to transition? And so it's really our job as advisors to ask and facilitate those tough questions about who are the players, what are their skill sets, what are we trying to accomplish with this mission, and do we have the people there that are going to be able to take this to the next generation, or do we need to think of other alternatives to the wealth as to how it will be passed down after maybe mom and dad or grandma and grandpa are gone?
Yeah, this is often a situation, or at this point in the conversation, philanthropy will come up. So we did have a question about that. How can an individual transfer or bequeath his entire estate, all assets of every type, to a nonprofit foundation or trusted family member advisor of that foundation with certainty and without tax consequences? So, a little wordy. Can you give it all away?
And I guess the answer is it's very carefully, I guess, is how you do that. But and very often we'll sit down with the family, and there is a large charitable gift that they want to make, and often they want to be able to have some control over how that money is going to be managed going forward after they're gone. And so this is often where we're talking to them about creating perhaps a private family foundation. It really depends on what is the amount of wealth that's being transferred. Typically, when we're doing private foundations, we're looking at funding those with $2 to $5 million. If it's something less than that, we're probably going to have a discussion with the clients about a donor advised fund or some of the other alternatives that they may have. Now, some clients, they want all the control, and the advised fund is not going to be for them. But really, when we're looking at large transfers at death into a charity or to a private foundation, you need to be very careful with how you're doing that to make sure that the donor's goals are going to be achieved. And with private foundations, if it's going to be something that's really going to be funded at death, typically we recommend that foundation maybe be set up in advance and seeded with some money so that we can really create a strategy to make sure that foundation is going to accomplish the goals that the donor wants it to accomplish. So making sure that there is some type of board structure set up, that there's a clear mission for that foundation so that we know what it's all about. And then we have a strategy to communicate what that mission is, to educate other family members that are going to be involved in the foundation going forward, and to really have it set up so that it is sustainable over multiple generations.
Well, timing, obviously, getting that out on the table is important. If there is a decision to make a philanthropic bequest or an allocation to charitable organizations, someone said, how do you work with charity representatives? We have a few here today. Almost every major charity has development staff who are willing to work with potential donors, identifying the areas of interest. It's a very valuable process for people to see potential outcomes of the donation they intend. If they say, well, I'd like to name something significant, and it's not quite a shopping list, but there are levels. You can't get your name on a building for $10, but if you had $10 million, they'd probably think about naming part of a building. I think an important question that I've heard used to stimulate the philanthropy conversation is, if you have enough in your wealth to take care of your family members in the way that you desire, what are you going to do with the rest of it? And that can trigger some thoughts. Well, maybe there's some friends, or maybe they say, well, it would be a windfall for friends. You know, nobody ever says, do you know any charities that I could give to? It's happened a couple times in my career, but most of the time people have some favorite charities, and that begins a path of exploration with the charity, family exploration about the things that are important to them, that they would like to see the family support, and perhaps the family name at their favorite institutions.
And for those that are perhaps looking and saying, you know, we're just on the cusp for what we want to give away and what we need for our family, and doing as many projections as you can do, we have the ability in drafting, and I know this is slightly technical, but to put in a formula so that we know generally we want to give this much money. A family has this choice, but they also know that the family needs a certain amount that they want to pass down, and so we can draft that so there's not a concern, oh no, you know, the stock market's down this week, we have to amend and edit and change. That formula, that little formula can cause, I think, a little bit of comfort too.
And Kate, one thing I think that's important is that we have this discussion with the clients about charity, because I've seen in my practice a number of times families who initially come and they really don't have that on the agenda. And partially it's because they haven't really done the numbers, and they think, you know, I have just so much in my pie, and if I leave a half of that pie to charity, it's going to reduce what I can leave to children and grandchildren. So often where we can help is letting them see that through creative strategies, often by reducing the tax in the estate, we can get just as much, if not more, to the heirs at death, and still include charity in that planning. But if you don't have that discussion, sometimes they're not aware that there are these techniques, and through specialized trusts and utilizing tax savings, that we can make the pie even larger by including the charity in the overall planning. So I think it's important that it's something that clients don't come in sometimes thinking, I give while I'm alive, but at death I want to make sure everything goes down to my children and grandchildren, thinking that they would be missing out on something if they had to leave something to charity. So that's a discussion that's important, I think, to have with all clients.
Here's a question from a financial advisor that I think fits here. How can the financial advisor help in legacy planning, influencing outcomes or promoting initiatives? You know, we're kind of a mixed crowd of clients and advisors, and so from an advisor standpoint, I think it's another arrow in your quiver. There is an abundance of information and books that are very helpful. Preparing Heirs, I think, is one that came out of Harvard a number of years ago. The statistics we quoted were from a book by Roy Williams, who's been in the family business legacy planning for probably 50 years, and he's written extensively. There are all sorts of, if you go on the internet and search for legacy planning or charitable planning as part of estate planning, you'll find a lot of information. So I think as a financial advisor, coming to the table with your technical skills, knowing that people may have an inclination, I have a philosophy that includes that I think people are born with a generosity gene. They've got something in them that compels them to share out of what they have when somebody else has less. So that touching that as a trigger point can start a conversation, and from an advisor standpoint, you've added value to the relationship.
And from an advisor standpoint, the advisors know what the basis is in assets, and so there's that, I think, is just beyond. I mean, that value is more than anything else, is that you have that soft knowledge to say this is how you can move forward, but then you can do it in a tax efficient and effective way.
Okay, let's move into what I refer to as hard conversations. What are some of the planning issues that present problems, not necessarily from a philanthropic standpoint, but just generally the kinds of assets that people accumulate, excuse me, I got ahead of myself. The nature of family relationships, marriages that are not working so well, grandchildren, who are having problems. So, Kate?
Our job, as you touched on earlier, is not looking at the very specific legal aspects. Much of our job as advisors, as estate planners, is the personal knowledge we have of our clients. You can have a client come in and look at their balance sheet and draft a perfect plan, but when that client comes in and says, my child, I'm not sure if their marriage is going to last, or my child has a certain problem, that changes things and it puts it on a dime, and you have to move immediately into something else. And so some of our little issues, we have remarriage, and that could be at the client level, where the client is saying, I'm madly in love and I'm getting married again, and my children are rotten, and I don't know. So clearly nobody's ever had that happen before. Or the kids may come in and say, oh my gosh, mom and dad are divorced and there's this new person and we're worried about them. And so those are the conversations you don't have looking at a balance sheet. And that's where, as advisors and as clients, you spend time with your advisors, with your clients, to figure out and find those little areas. And then documents can be made to protect. We can protect, maybe not 100% in remarriage, but we can say, okay, we know we have a we have a little bit of an issue here, so we're going to provide for the new spouse. We're going to provide that the future ex-spouse of our child we haven't met yet is excluded, and we can do that. But it's really discussing it with that client. The conversation that is very interesting, which 10 years ago, 15 years ago was not an issue, is tell me about your grandchildren. And normally it's, Johnny's doing this and Johnny is doing that, and isn't he wonderful? And yes, he is. Is he biologically yours? Because anymore it's not as simple as mom and dad adopted child. Now you have grandchildren that maybe sometimes they're adopted, maybe they're not adopted, maybe they're biological, maybe there's some artificial reproductive technology. I don't want to know about all of the things that go into how you get your grandchildren. I just want to know if you want to provide for them. And if you want to provide for them, we need to know that so we can take care of them. Because at the end of the day, our job is taking care of our clients' families. And so it means disclosure.
Yeah. And I think what's important there is, we can have a plan that's drafted fantastically, but if we have also the wrong players, controlling that plan, that can cause problems. So when we look at those hard questions, talking about how do your children get along? I see you're naming your oldest daughter as the trustee. Does she get along with her two brothers? And has she always gotten along with her two brothers? I see you're naming your current spouse as the trustee. He or she is not the biological parent of your children. There's going to be control there. How do they get along? And it's always, and the first time you ask that question, it's almost like, oh, they get along fine. You've got to kind of pick away at that a little bit, because where we see very often problems where the plan does not get fulfilled successfully is because you've put people who are at odds and probably have been at odds for a long time on different sides of the equation, and right after the grave is lowered, or the body is lowered into the grave, the lawyers come in and litigation ensues over they can't be in charge of my money, and that's ridiculous. And so we really need to be asking those questions that are tough questions of how do these people get along, and you've named this person as your trustee. Is that the best choice? And are they going to be able to make hard decisions without the other family members kind of getting upset and maybe lawyering up? So.
Yeah, we have a lot of tools to address those issues, things that add flexibility to anticipate circumstances that may not be known. And in most cases, if there are problems in a child's marriage and the parents become aware of it, they're on the phone with us saying, things are falling apart, what can we do? And for the most part, an underlying principle of most state laws is there's no forced inheritance right, even for children. Only spouses are protected. So if I'd say probably 95 to 99% of our plans don't automatically include in-laws. And so that'll come up after the fact. They'll hear something, a horror story from a friend, and all of a sudden, well, geez, I don't want my son-in-law or daughter-in-law running off with the inheritance I intend for the grandchildren. So that's kind of a routine addressing of a common issue, and there are variations on that. I think the hottest issue or most difficult issue to deal with is unequal treatment of children or grandchildren. Mike, would you share a little on that?
Well, yeah, we see this a lot, especially in the family business area, where we have, typically what is maybe the largest asset in the estate is going to be passed down to just certain children because those children are active in that business. And there's a concern about, well, that isn't really fair because the rest of the assets don't equalize that out for the children who are not involved in the business. We also see it where I just had a case earlier this week where the client came in and explained that she's been supporting her daughter over the years with fairly significant gifts of, helping her buy a house and helping her pay for some medical needs. And, she was struggling because she said, "No, what do I do about that? So I've given her this wealth already. Do I take it away when I die? Do we do some kind of equalization? How do you figure that?" And there's no right answer to any of these questions, but our job is to help the client really find out what they want to accomplish. And then there are a lot of ways that can be taken care of in proper drafting. And it's not so much that it's going to be equal, but it will be fair and it'll be consistent with what those values are that the family has.
You have a favorite guru who says you love your children equally, but you treat them uniquely according to their specific circumstances. And so if you're looking at success of the plan, and you know that if you leave a particular child with some kind of an affliction or addiction or whatever, you're almost sure that purpose of helping the child is going to be frustrated because the inheritance will be wasted. Special needs children and grandchildren also present difficulties. Mike or Kate, you want to address that issue because it seems to come up, and autism is kind of not rampant, but it is frequently an issue. Lots of other health issues for children or grandchildren.
And we can draft flexibility into plans. So exactly as you said, you want to make sure that the inheritance goes for the benefit of a child or grandchild. You don't want it to go to the state for a few months in a skilled care facility if it can be used to enhance a child's life. And so in our documents, we can draft a specific special needs trust. We can say that it's going to go to these family members, but if something should happen that the special needs child would be an inheritor, then it will remain in trust. And we write wholly discretionary trusts all the time. But the key is building the flexibility in so that if everything is okay today, but a child has an accident 10 years, 20 years down the line, that child can still be cared for. And oftentimes you need to work, if it's a grandchild, you need to work with the parents, because parents will often have their own counsel, whether it's a financial advisor, their own lawyer, their own CPA. And this is where that family meeting is important. Junior, I know that grandchild A has this issue. We wanted to do something for grandchild A. Are there any things that we need to know as their parents to implement that so that grandchild A is taken care of?
And very often we'll see when families come in and there is a child with special needs, that they really have no idea of what they should do. In some cases, they don't know if the child will ever need to have any kind of state or federal assistance. I've had clients who come in and said, I want to disinherit that child because if I leave something to them, it'll disqualify them from any benefits they may be receiving. So I'm just going to leave everything to their siblings and cross my fingers that the siblings are going to take care of their brother or their sister.
And their siblings' future ex-spouses.
Right, and and you see, the siblings can die out of order and can get divorced and can get sued, and so that's really not. On the other hand, I've seen clients who've come in and said, I'm leaving everything to my child with special needs and disinheriting my other children because that child needs it most. And so what's important is that they don't know what the options are. And so being able to sit down with them and plan and ask hard questions about the child and their goals for that child, we can create a plan that's going to take into consideration what may happen. And it's important when you have a family, within that family there is a child with special needs, that the family communicate these issues, because we see quite frequently where the children, there's a grandchild with special needs, grandma and grandpa pass away, and they leave money directly to that child, not realizing that it could ultimately cause problems with eligibility for certain benefits. I actually had a client last year, mom died, my client's brother had special needs, he was in a group home, he was doing this vocational training, his mother left him money directly. And it disqualified him. We had to then place that money into a first-party trust, which now, when that child dies, if there's anything left, it has to go back to pay Medicaid as opposed to going to other family members. So when there is a family member that has special needs, it's important that all the other family members understand that there are certain ways that money can be left to this child. And and I always tell the client that it's you're not really asking your brothers and sisters to leave them money, but you just need to tell them, hey, if you were to do that, it has to be done in a special way so that it doesn't disqualify them. So a lot of issues that come out of that, and there's a lot of education that needs to be done with the client to help them understand how the rules work and to make sure their plan meets their goals.
I have a conversation occasionally with a client who says, well, that sounds too complicated. I'll just leave it to the brother, and he'll be sure to take care of his sibling. And he may or may not be sure. When he gets the money, he may decide, oh, I kind of like that new boat. Who knows? Or he could have creditor issues. And so the things that he would have done out of good intentions, the property's gone so it is important to address the issue, and it, just almost in every situation is best addressed by a trust. Now, this is kind of a soft issue, and do we have any pet owners here? Yeah. And it seems, trite, not significant, but people love their pets. And when they get up in years, their kids are no longer in the area. So who's going to take care of the dogs, the cats? So would one of you like to address the issue of pet trusts?
It sounds funny, but my parents are the prime example. We moved out, they have grandchildren, they have these dogs that are loved and cared for and return their love, and they don't want them to go just somewhere. And so oftentimes we'll have a client that will want to care for the pet. And so sometimes it's tied to the new spouse, where you say, new spouse is able to get the pet and X dollars, or sometimes you just set aside a little fund. And that person that cares for the pet gets the fund. Sometimes they can be trustees, sometimes they just get an outright distribution to care for Scrappy. But in other times, you have horses. You have clients with horse farms that love these horses and should, and they don't want to see them just sold off and gone away. And so these trusts are actually very important and very helpful to give people peace of mind.
Ensure that that's where I've had a number of clients who've had horses and have set up trusts for those horses after they're gone, so that veterinary care is continued, the boarding is continued, and that. But again, the questions of how much are we leaving? Where does the money go if the pet passes away? Does it go back to the caretaker? All of these are kind of questions that you have to go over with the client. You don't want somebody who says, okay, there's $5,000 here, and as soon as the dog passes, I get the money. I think you kind of set up a little bit of a conflict of interest unless they're a real dog lover. So,
kind of see old Yeller going on.
You definitely want it right. You want to make sure. But again, the idea here is that clients understand that this is a possibility. Michigan passed its law that allows for money to be left in trust for pets probably 15 or 20 years ago, and I actually had done a number of these horse trusts and so got interviewed, and I got a call from a client who I was actually helping him negotiate transfers of his business, and his wife was reading the paper saying, "Oh my God, there's a lawyer in the paper here that drafts trusts for people's cats and dogs." And then he said, "Well, who is it?" And he told him my name, and he said, "I spit out my coffee because you're also negotiating my business, and you're a dog trust lawyer." So, but I think a lot of people don't realize that pets are important to people, and there are ways to make sure that they can be protected if you leave and someone has to take care of them. So.
Okay, we'll get back to serious discussions. Social issues come along, and they alter the way we think about things. So the LGBT planning was kind of no real certainty. Now that it is legal to be married in all states, some things have changed and some things have not. Both Kate and Mike have had experience in this planning, so I'll turn you loose for a few minutes.
Go ahead.
I have to say, I don't think we practiced this part at all.
Well, I mean, obviously, there was a lot of things that had to be considered prior to folks being able to get married in same-sex marriages. Today, I find most of my counseling I'm doing with is now that we can get married, should we get married? There are a lot of issues that come into play with taxation, with homestead exemptions, and with benefits that are available that have to be examined in that question. But I think there still is a lot of issues that come in the LGBT area where, even though it is now law in the United States that they can be married, still there is a lot of family issues and folks that understand and feel differently about things. It is important that we all have good documents that name who we would want to handle our affairs if we get sick or if we pass away, and to review those documents regularly, and whether you're married and it's a man and a woman or a woman and a woman. These are issues that still have to be addressed. I think I've had some clients say, well, now that we can get married, we don't have to worry as much now about the estate planning, and it's still obviously a very important issue for all of us.
Well, and within that, it is the same, but it is different. So whomever chooses to get married, that's great. But in same-sex couples and in opposite-sex couples, there's the issue of if children are biological or not. And so that, again, goes back to that hard topic. You want to make sure as a planner that you're protecting the couple's children now. And more importantly, the grandchildren, because let's be honest, parents love their children, but grandparents really love their grandchildren. And so it's making sure they're cared for. It's making sure that the documents are in place. And whether they should get married, I mean, golly, anybody here, that's your choice. And I think, Mike, you said it very well. You make the decision whether to get married or not, and we'll talk with you about how best to implement that. And just like opposite sex couples that say we're getting married and you say, oh my gosh, you have 14 IRS liens against you and you're getting ready to go to jail, I don't think that's a good idea. We may still say that to a same-sex couple. Hopefully they're not, but so those issues are still there. Generally, we're not going to tell people whether they should get married or not. That's their choice.
Okay, let's move to what I started to say earlier. There are asset issues, collectibles, and they might be lumped together as the indivisibles. More than one child has an interest in that painting, or a collector car, or piece of jewelry. How do we deal with those?
Well, I mean, very often when I'll have a client who has an extensive art collection, for instance, there are a number of issues that come up with that. Number one being, could the children or grandchildren even take that art into their homes? Do they have the ability to store it properly, to maintain it properly, to insure it properly? In addition, I have one client who has an extensive textile collection. There are issues of valuation. What is that worth when they die? And if there's an estate that's large enough where there's an estate tax issue that's there, that becomes an even more important question to answer. And so what we really want to work with clients who have large art or any kind of unique asset is making sure that we understand what that asset is, how it can be valued, how it could be transferred, if it can't be transferred really realistically to the children or the grandchildren, is there a market for this asset, and where do we find legitimate people who can come in and give us a valuation and then maybe assist in the sale if we have to sell that collection. So these are all issues that probably the person who knows most about who the people are, who would be appropriate buyers, who would help with storage, who would help with insuring, who would help with valuing, those are the people you're sitting in front of now, but they're not going to be available after they're gone. Again, we have to have these questions, and we have to have a strategy to how to deal with that collection after they're gone.
What about the vacation residents?
Sell it. No, and that's actually very family specific. And it is not just the parents making that decision. Parents that own a vacation residence that they want to pass down need to have this conversation with their children, because they may find a whole host of things that pop up. The child that lives on, 3 children, 1 on each coast and 1 on the shores of Lake Michigan, and all 3 children are to equally care for the Lake Michigan cottage, except that only 1 is going to. Well, it's not really fair to that 1 to leave them all 3 equally when the 1 is going to be running up in the middle of the night because something's broken. At the same time, you may have families that have been thinking about this for years, but this is where it's really important at that family meeting to bring in the family and say, what do you think about the vacation home? How do you see yourselves using it? Because there are times that if the children aren't going to use it, then you make your peace with it. You have wonderful memories. You make your slideshows of it. You tell your story about it, and you sell it.
And I think that with the family cottage, and in Michigan we have certainly a lot of those along the lakes, that what we see is just like the family business, that the success goes down as we pass. The brothers and sisters often can find a way to get along. When you start dealing with cousins or second cousins, that starts to break down. And very often we'll use some type of entity to hold the cottage, so that there are clear rules as to when one sibling thinks it needs a new roof and the other 2 don't want to pitch in for that, how do we deal with that issue? So whether it's a family LLC or whether it's some type of trust arrangement, we want to make sure that we kind of think through what are the issues that could come up with regards to the maintenance, the taxes, the additions that may need to be done, and how will those be allocated among those who use the property. And what if someone, as you said, lives on the East Coast and will never use it, doesn't want to participate in it, but certainly wants to get their 1/3 of the value out of it and put into their account? How do we deal with those issues? And again, by proper planning, typically using some type of entity to hold the vacation property, that's a great way to accomplish those goals.
And I think it's not unusual, in some families, especially if, say, one child inherited from their parents, and they may not have gotten a lot of other wealth, that in order to deal with it, if you're going to try to keep it together, you may need some independent funding. And so we might call a life insurance agent and say, is there something that we can use to create a level of wealth that will fund the maintenance or help to equalize if there's more than one child? You'd be able to give cash from life insurance to those who aren't interested in continuing the ownership. We're going to go to trying to prepare for post-death disputes. And there's a question pertinent. What do you suggest when you know your family is dysfunctional? Actually, they all are. It's just how much. Children don't get along. How do you prevent fights after you're gone?
Well, I think, again, looking at who's going to be in charge, I think that the choice of trustee can help in minimizing the chance of a dispute. Communication up front. Often when we see disputes, it is because people are surprised with what the will or the trust actually states. And so having a communication, I always tell clients, you don't have to get your children's permission, but I'd rather have you let them know what you're doing and have them yell and scream at you now than sue their brother and sister because they're mad at you for doing something that they don't understand why you did it. So that communication, I think, can go a long way. And then on the backside, having well-drafted documents that can minimize. In Michigan, a no contest provision, which says if anybody fights over what we did, they potentially get nothing. In many cases, can be, if not a discouragement to that litigation, can actually have some teeth in it and prevent somebody from causing a lot of problems.
Absolutely, and not being afraid to look outside of the family for your trustee or your executor. If you know that you have issues within the family, you don't want to, if you have 2 children, put your smart, responsible child in charge of the one that has severe addiction issues, because you're going to ruin that relationship. And so something you may want to consider is having a third party, because that will keep some sort of family harmony, because the younger child isn't going to be lashing out at that older sibling or younger sibling because they're not getting what they want.
And I think sometimes, in terms of communicating what your overall idea was and putting together the plan, in some cases clients don't want to have that conversation with their children while they're alive, or maybe can't have it for different reasons. So some type of letter from the parents that kind of outlines here's why we did what we did, and so that it sometimes can answer those questions that if we don't have something from the parents, are going to always maybe fester among the family members and cause those disputes.
Okay. Before we go to a few questions, I want to close with some discussions of ways to communicate that we haven't covered those important values. Kate, can you talk a little bit about the ethical will?
Absolutely. It's one of my favorite things. It's very simple to drop assets to this child or that child, say that you're going to get distributions at these ages. But somebody needs the story of how grandma or grandpa came to America, worked very, very hard, earned money to put the child or the parent through school, and if it wasn't that they saw how hard their parent was working, would not have the value system that they have. And that's what an ethical will is. It's saying these are our values. Our values as a family are that we all get up on Sundays and watch the Browns, no matter how poorly they play. Or the Lions for our Michigan watchers today. So it's putting those values in place and letting your children know. And how often does a client say, well, we believe this and we believe that, and you say, well, have you told your children this? Well, they should know. Well, they should. And so we've seen quite a bit of success with families writing to their children, and it could be, it depends on how a person thinks. I've seen clients that are very linear thinkers put it in bullet points, and it's just very bullet pointed out. This is value 1, this is value 2. I've seen free-flowing, lovely, beautiful stories to children and grandchildren about why they are special and how they remind their family member of an ancestor. And those ethical wills, especially when fare is not always equal, go a long way in bringing financial harmony or family harmony together.
I'll mention in passing, it may be available on Amazon or somewhere out on the internet. There was a movie a few years back called The Ultimate Gift. It's maybe a little preachy, but James Garner is the patriarch, and he conveys this kind of information by video. And Bill Cobbs, a Cleveland-born actor who's had lots of character roles, plays the attorney, and the grandson is challenged to work towards the ultimate gift. It's fairly moving, maybe a little preachy, but it's an interesting way in which he chose to communicate what was important in his family. We won't get into too many of the solutions in drafting. We've touched on a number of them. We thought we'd leave time for that, but there are enough questions that I think I'll start through those. First one is, how often do you recommend that estate planning documents are reviewed and or updated outside of a life-changing event that would, probably trigger a phone call?
Our firm protocol here is every 5 years. And I met with a young woman today and said, and she, you know, it was her first will and trust, and it was very exciting. And I said, we're going to visit every 5 years, kind of like you go to the dentist twice a year, you're going to hear from me every 5 years. And sometimes we'll change things and sometimes we won't. But just like the dentist, if you have a horrible screaming pain in your tooth, call me. Well, don't call me, call your dentist. But if you have this big family catastrophe or a change in what you want to do, call. We're here to help. Or if you just have a question, that's what we're here for. And so that 5 years is a nice, you know, it's twice a decade. You get a quick read through. Sometimes there's changes. Often there aren't. But it's a good rule of thumb. I think we think so.
Right. And I think some documents, like powers of attorney, while they don't expire at any point, institutions tend to look and say, oh, geez, this is 5 years old or 10 years old. Is it still good? They ask that question without any legal authority to ask it, but it raises issues. So refreshing those types of forms that are very useful during the client's life is very important. Here's one that stretches the scope of communication. How can you determine if there are other trusts or plans in the family of the in-laws, that is, your daughter-in-law or son-in-law may be from a wealthy family, and so how do you do planning and integrate that? And so, as I say, it stretches the bounds of communication. You know, it's something that some people wouldn't naturally disclose, but if they're running parallel with this kind of approach, then it ought to have been discussed with their child. And so the two children can talk based on a common experience of the values of the respective families and the plans. So there would be an opportunity to integrate. You know, every now and then I'll have a client that, oh man, you know, my daughter-in-law's family is loaded. You know, we don't have to worry about them, because you know they may choose at that point to unequally fund education of grandchildren, saying the grandkids on the other side will be well taken care of. We don't need to worry about them.
And then, you know, and the kind of the double-edged sword that is most trust is the privacy that is attached to that, and clients love the fact that they keep private, you know, what they want to do. But then that also, you know, if you can't get it out of them, you can't get it out of them. And so, again, you can try with the communication, but sometimes you have to be careful about that when you're trying to kind of come up with what you think the other side of the family or the in-laws are doing, and you're not exactly sure.
Right.
So.
And I've seen it with families where, for example, 1 year family A, the one spouse's family pays for education, the next year the other spouse's family pays for education. And that's where you do get real integration. But I think that starts with a discussion with the children.
Do you recommend naming a contingent charity like, Ginger, is this yours? The Cleveland Foundation, in case the primary charity no longer exists. Any thoughts?
Well, I mean, it's certainly anytime that we're talking to clients about who their beneficiaries are, whether it's the primary beneficiary or kind of those final contingent beneficiaries, it is important to ask that extra question. Well, what if they're not here? What would you want to have happen? And so I think it is important to be thinking down multiple levels as to where that wealth will pass if the initial person named is not there or the institution no longer exists. So.
In some of our documents, when assets do go to charity, they will say, to this charity, if it has a different name or if it has been merged to the new one, if it no longer exists, then sometimes we'll have an alternate. And then same provisions again, and eventually we say the trustee may choose a charity or a foundation that fits within the IRS guidelines.
Okay. This is a little harder question. Is it feasible or possible or feasible to transfer a closely held business to a non-operating private foundation? Client is the sole member of an LLC holding residential real estate, wants to protect employees of business by providing continued employment. That's it would be an interesting case. I know there are a couple of cases that I'm aware of where through some very careful planning, a very large family-owned business ended up in a charitable entity, which is run by some family members and some employees. And they've done it all on a qualified charitable basis. A couple years ago, they got a special private letter ruling. The name of the company, because it's all public, is Barnhart, I think, Crane and Rigging. They're out of Tennessee, and they do nothing but move big pieces of equipment. And they have these things they create that carry, you know, like they may have 40 wheels, you know, that carry heavy equipment. They've moved the space shuttle and things like that. But they had some very smart attorneys who put together a plan, got it all cleared, and so it is possible. It wouldn't be inexpensive, but it would take some very sophisticated planning.
Well, and this being McDonald Hopkins, I think we would be remiss if we didn't suggest an ESOP, at least for part of something like this.
Yeah. Right. Any other questions? Either of you have anything you'd like to cover in a closing? We're a few minutes ahead.
Well, I mean, I think just the key is that we didn't touch on this real in depth, but there are drafting strategies, obviously, that can really solve a lot of these problems. It does take work. It takes a thorough discussion with the clients of what their overall objectives are. But today, with the estate tax exemption, for a married couple sheltering almost $11 million, the tax issues are not really driving as often, this planning as some of these other issues we've discussed. And so clients are worried about their children and their grandchildren and in-laws and outlaws and predators and creditors and all those that are looking to step in and capture that wealth that otherwise they would have going to their family. And that's really where, through discussions, through good planning, we can solve those and give that peace of mind to the client that they're really looking for, and push them into that 30% that's going to be successful in transferring their wealth, as opposed to the 70 that the wealth transfer typically turns into a very good year for the beneficiaries, and that's about it. So that's really what we're all about.
Okay. Anything else, Kate? Okay. Well, thanks to Kate and Mike. I want to close with a thought for all of us. Some of you know of David Brooks, a New York Times columnist, who speaks in terms of resume virtues and eulogy virtues in one of his comments and in his book, The Road to Character. And the gist of it is that your family and friends and coworkers may remember your lifetime of accomplishments, but they will more likely remember and be affected by the ways in which your life touched theirs. Your virtues are reflected in your values and expressed in the life you live. These will be transferred along with your valuables and will be the lasting legacy you leave. Sorry about the motion. We promised to conclude at 1 p.m. We made it. If you have additional questions here in Cleveland, we'll stick around and try to answer them. You can still email questions over the internet, and we'll get back to you by email. Our team continues to follow the latest developments regarding estate planning issues. One of the ways we communicate this information is on our online community, The Business Advocate, at businessadvocate.mcdonaldhopkins.com. The URL is on the front page of your handout. We look forward to hearing your thoughts and perspectives about the subject discussed here today. We'll email a survey to you on the business hour today and encourage you to respond. Thank you very much for joining us.